just want to show you a very important case. This case of Turner and Bromets is a fascinating case, a 2016 decision, and what happened in this case was as follows. Miss Turner sued her solicitors. She alleged that they had been negligent in a number of distinct areas. Area number one, she said that because the parties were making unequal contributions with regard to the purchase of the property, there was a conflict of interest that meant Bromets Jackson Heath could not act for both parties, that she should have been told to get independent advice. Now, she failed in that connection because what the court said was it's perfectly acceptable to act for two parties who are buying a property together, provided that their objective is the same. There could not necessarily be a conflict of interest just because they were making unequal contributions. The important point was that the parties were aware of the significance of those unequal contributions and also aware of the significance of the documents that were drafted. Ms. Turner's claim failed for a number of reasons, but one of the big things was that the solicitors had, throughout the transaction, provided her with a full explanation of the conveyancing process, of the documentation that she was signing, of the significance of that documentation, of the significance of an disparity between contributions and how the documentation recorded that disparity. So there were attendance notes, there were file notes throughout the transaction that were clearly identifying that Miss Turner was well aware of her position and that she was going into this transaction with her eyes wide open, having been properly advised. So this case highlights the need to keep records of advice and conversations with clients, particularly with regard to co-ownership. Now, important point, generally speaking, you're not going to be in a position to make a note of every conversation and every attendance, a detailed note of each and every conversation and attendance with every client. But there are certain types of conversation where I say you do need to make a meticulous record of what is said, and where in particular a client is wanting to proceed on the basis of a set of instructions that's inconsistent with your advice, then I'd want the client to sign a copy of the attendance note, and I'd want to email the client to confirm what was said and to confirm what the instructions were. So again, let me give you an example. I'm buying a property with my partner. We're paying £100,000 for the property. I'm paying £20,000. My partner is paying in law and in equity, meaning that the beneficial interest will be divided on a 50-50 split. In those circumstances, I would have an attendance with the client, either a physical or virtual attendance. I would explain that what you're proposing to do doesn't make sense. The sensible thing to do is to have the beneficial interest divided so that it mirrors actual contributions, but that the parties have agreed that they are not going to accept my advice. They're asking me and instructing me to proceed on the basis that they're buying the property as joint tenants in law and in equity. In those circumstances, if I've had an attendance with the client, I might ask the client to sign a copy of the attendance note. I would certainly email the client to confirm the advice that I'd given. This important point about keeping a record of advice and conversations is so important. And if the client is asking you to proceed in a manner that's inconsistent with the information that you're being provided with, I would ask the client to sign a copy of the attendance note to acknowledge safe receipt of the letter or the advice that has been received, to make sure that the client is aware of the significance of the advice that's been given and aware of the fact that what they're asking you to do is contrary to that advice.